Hello and good morning. My name is Francesca Table and welcome to the Emerging Tech Law podcast. Today, we'll be speaking about non-fungible tokens, otherwise known as NFTs, with a prominent list of intellectual property and securities lawyers to help debunk what NFTs are and to discuss some key issues in this industry. So in no particular order, let me introduce you to our speakers today. First off, we have Rudolf Haas, who is a partner of King & Wood Mallesons in Germany, and he will be covering securities law. We also have another securities lawyer, Diego Ballon Ossio, who is a senior associate at Clifford LLP. And then on the intellectual property side, we have Alana Kushnir, who is a director and founder of Guestwork Agency. And last but not least, we have Andrés, Chomczyk, PhD researcher at Vrije Universiteit, Brussels. Thank you all for joining me here today.
I believe in most jurisdictions, the answer for NFTs will be no. Of course, the answer in each case depends on the features of the token, but typical NFTs, if there is such a thing, given how rapidly this space is developing, have characteristics which are likely to take them outside the definition in most jurisdictions. Well, first of all, most jurisdictions, including the two I actually know anything about, which is Germany, more broadly the EU and the US, have a substance over form approach for the question, what is a security? So the fact that we're talking about virtual assets is not going to answer the question for us. The US definition says a security is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. Now, if one person acquires an NFT, holds that in a wallet in the hope that it can resell it later at a higher price, there is still no effort of others and there's no common enterprise, because if you're looking at the typical NFT, as I said, let's say in the art space, the artist has created the NFT and is done. There is no further obligation towards the owner of the NFT to do anything further. And Ethereum world, normally the NFT is regarded as indivisible. So you're not sharing with others. So there is no common enterprise. And there is an even broader definition of financial instrument that we also have to look at from a regulatory perspective. But you still get to a similar outcome for a similar reason. There is the element that the ownership of a security gives you access to a future payment stream, or at least a potential future payment stream. Germany has an even broader definition of at least financial instrument, not security, a specific definition of crypto assets. That doesn't refer to a future payment stream, but it does require that either people accept the token as payment or that people hold it for investment purposes. Now, that last element opens the door for many, many things, but I would argue that you still have to read the traditional concept of a security or financial instrument into this definition. And this is where the non-fungible part of the NFT comes in. As an individual item, there can be no market price that you can derive from how others are trading in the same instrument. And you also don't usually have an underlying or reference value that will help you with pricing. And therefore, I would argue that this is still not covered by the broader German definition. Not everything of value is a security. Van Gogh painting doesn't become a security just because some people acquire it in the hope of reselling it at a higher price. Now, I did mention that there is a caveat, and that is the concept of fractional ownership. If we stick with the Ethereum nomenclature, because that's where I think the blockchain, most NFTs are currently being built, there is the concept of shards where you can tokenize your NFT. But, and now we're getting technical, not in a tech sense, but in a legal sense, by creating shards, you're creating new tokens. And that doesn't change the characteristic of the NFT itself. It's just that the owner of the NFT has created shards. And for those shards, you have to answer the question separately and the outcome may be different. If you use shards as a crowdfunding method for acquiring a cool NFT, which you think will increase in value, then the shard buyers are investors, and the US SEC and the EU regulators are probably going to tell you that the shards are securities because the holders are buying into them, into the future cash flow of from the resale. But you could use the same shards to secure that same cool NFT for your local museum of modern art. And the purpose of the shard is to create a permanent record of the donors who made the acquisition possible, like you might read on a plaque under the picture in the art gallery. And then that very same shard wouldn't be a security. So I guess the answer is it depends, but generally speaking, it's easier with NFTs than other tokens to kind of stay outside the definition of a security.
Thank you. That's a fascinating answer. And Diego, I'd love to ask you a very similar question. Since we've talked about the regulatory classification of tokens and if they're regulated investments or not, who needs to consider this question? And is this something that the artist or the issuer needs to worry about when they use a marketplace?
Thanks, Ranki. Yeah. So I think I'm absolutely with Rudolf on this one. It is the case certainly in the UK, and so far I'm aware in Singapore and in other jurisdictions that generally the test that Rudolf has set out applies with nuances, but broadly that outcome is probably the case in most jurisdictions and certainly in the UK. However, that is only the first step when you're thinking about regulatory licensing and prohibitions. And so I'm going to go a little bit into the weeds around how financial services regulation works, because generally it is not enough to have a security to trigger certain things. It is all about what you do with the security that will make you fall within the regulatory perimeter, as we call it, or not. And if you are within the perimeter, then there's an obligation to be licensed or registered or whatever it is that you, or to rely on an exemption or exclusion or whatever it is that the local framework asks you to. And then depending on the local jurisdiction, if you haven't done that, if you haven't sought the registration or the licensing, you are in breach, and that may amount to a criminal offense, and that may have then consequences for transactions that you are then entering into because they may be invalidated as a result of the breach. So that is generally how financial services perimeters work. And so the first question is, what is it that we're dealing with? And that question can be answered on the basis of Rudolph's test. Broadly, is this a security or not? And in the jurisdiction where it is a security, then the next question is, right, what is the activity that we're performing here? And is this activity a regulated activity that requires me to be licensed in order to carry it out? Or is it something that I can just do because there's an exemption or because it's simply not regulated at all? And so the question really needs to be considered by everybody in the chain, and their particular characteristics and their particular position in respect of the NFT will be, again, very fact specific. But let's start with the artist. The artist that is issuing the artwork, that is creating the artwork, they may not be minting the NFT. They may, work with somebody who is minting the NFT for them, in which case the artist is entirely outside the scope. Now, the question is around, is the minting of the NFT equal to the creation of a security? Because if that is the case, then it may be that in certain jurisdictions, issuing the security is something that is regulated. Now, in the UK and generally in Europe, issuers of traditional securities like shares or bonds are not within the licensing framework. It is the intermediation of securities that causes an issue. There is a caveat to that, which I'm going to get to in a second. But generally speaking, a company or could issue a debt security, for example, and that doesn't trigger licensing requirements. It is the selling of the security that will, bring you within the scope of the perimeter. And so that test needs to be applied in the context of the jurisdiction and in the context of the classification that we've got. So assuming that the NFT is a security in those cases where it is, then is the person who's minting the security on the hook merely by minting it? That's the first question. Probably the answer is not. But then the question is the next person in the chain, and that would be the exchange potentially, or somebody else who is offering that security to people so that they can buy it, is that activity regulated? And generally speaking, the intermediation of securities, the selling of securities, either because you've bought them and are reselling them, or because just finding people to come together so that they can buy it, will trigger a licensing requirement. And so it's really, you need to really look at what is everybody doing and at what stage are we within the scope. Now, if you've got a very entrepreneurial artist that is minting the NFT and, you know, sets up their website to start selling them, then we may be in that territory, because, you know, if they're offering them directly, then we may be in that territory. The big caveat is that where the NFT is not a security, but is subject to some local crypto regime, then it is necessary to consider that question under the applicable local crypto regime. And so, for example, in the UK, the intermediation of securities, it's the same test. The intermediation of crypto assets will bring you within the registration framework under the money laundering regulations that we've got here in the UK. And that is a result of essentially the UK's implementation of the guidance that was issued by the Financial Action Task Force, which is an international global standard setting body that has created a definition for when crypto assets may be a risk to money laundering and you know may be furthering terrorist financing, etc. And so countries have put in place regimes in order to deal with that. And in the UK, that means that if you've got a crypto asset that is within the scope, then the issuance, because you're transferring it, may be an activity that triggers registration, as well as the intermediation. So you're actually very caught at the very early stages of the regime, and that is because of the UK's perception of how crypto assets need to be regulated, at least at the moment. Now, whether in the UK a crypto asset, an NFT qualifies as a crypto asset, that is a slightly different question. We come back to the test that Rudolf was setting out. And it's actually really, really dependent on the specific features of the crypto asset. The test here is whether the NFT represents value or contractual rights. And we've seen good arguments to support the position that a crypto asset, which is an NFT, which is gaining its value as a result of the art, and really people are paying for the art, not for the NFT, then that is the value that's attached to the art, not to the NFT. And, you know, to the extent that the smart contract that's pegged to the NFT is not a real contractual right, but really just, you know, the execution of something, then the NFT may be outside the scope of the perimeter. But it really depends on how it's been done, how it's been minted, and what the underlying rights are that are being sold by the NFT. I think one thing that people tend to forget in the context of NFTs is that not every NFT is the same thing. NFT is just a way of creating a non-fungible thing of something, but we really need to think about what is it that we're selling. You know, is it a licensing right to something? Is it really the art, the right to the artwork? Is it, you know, what is it that we've got here? And does that mean that it would fall within the perimeter?
Thank you so much. So Rudolf, in the case that an NFT is deemed a security, what are the NFT marketplace's obligations? And I would specifically like to look at, say, a crowdfunding platform such as Kickstarter, who are looking at introducing NFTs. So your case for the sort of tokenization of NFTs and sharding, if we can look at that and what those platforms' obligations are.
I mean, that question again depends very much on where the marketplace is based, which in itself, of course, in the metaverse is a very difficult question. Generally, in financial services, regulators tend to assume that service providers are actively targeting customers, and so they tend to look more at where the customer base is than where the service provider is located. But when you get to exchange regulation, the underlying assumption is that the customers are coming to the marketplace. And so the default is that the regulation in the country where the company running the marketplace operates applies, which gives operators some flexibility in terms of where they want to set up shop. If you assume that the NFT is a security, the marketplace is in the EU, and it then qualifies as a multilateral trading facility or organized trading facility, then you suddenly, under the relevant EU directive, have a long list of requirements, starting from the licensing requirement that Diego was referring to minimum capitalization requirements, qualification requirements for management, transparent rules, how orders are executed, prices are set, and many others. Of course, because of the rapid technological development, the lines have blurred quite a bit, even outside the crypto space, and where brokerage ends and where running a trading facility begins is increasingly difficult to say. A number of places have created regulatory sandboxes for the crypto world in an attempt to have an eye on the space without regulating it to death and have it flee to other jurisdictions. And so I guess regulators are trying to take a reasonable approach and tend to just look at it as financial services, but with a potentially lighter regime. But I think ultimately, when you run a marketplace, you will have to watch the regulation in the relevant jurisdictions. But depending on how strict that regulation is, you may not want to stop there, because finding the place with the lightest possible regulation and can still find jurisdictions where there is no regulation, that makes compliance easy. But being regulated can also be like a badge of honor, which may differentiate you from the competition. So as decentralized as this space is, I think there will be some consolidation sooner or later, because the marketplaces that have a higher trading volume are likely to be more attractive to investors. And I think the survivors that will capture most of that market will not be the ones that try and stay below the regulatory radar entirely, but ones that, in addition to getting the technology right, which will always be key, also find the right equilibrium between manageable regulatory requirements and trustworthy structures that also make institutional investors comfortable. And I think ultimately, currently the retail space is very important in the crypto world, but I think we're seeing a change here, getting to structures that are that also work for institutional investors.
That's a fascinating response, and one that I hadn't considered, that actually it is in the entrepreneur's best interest to self-regulate, as it were, to get credibility and to grow and survive as this market sort of consolidates. So Diego and then Rudolf, you mentioned concerns around terrorist financing. So on that note, are NFTs subject to federal anti-money laundering laws? And indeed, if they are, what are their obligations?
So there is the Financial Action Task Force guidance, and that basically imposes a soft requirement on jurisdictions to put in place regimes. And I say soft because essentially people are asked to do it, and if they don't, then they get reported against, and the FATF basically says you're not compliant jurisdiction, you're not following our rules, and so jurisdictions are under pressure to put in place these rules. This is where the dreaded travel rule comes in, and that people have been discussing. But also this is where the registration requirement for virtual asset service providers comes in, which is effectively translate into money laundering registration requirements for crypto asset services providers in the EU, in the UK, and in many other jurisdictions. So as I was saying, the test here and the FATF definition is a little bit broader than what we expect on the securities definitions. And what they look at is essentially in the UK is the question around value or contractual rights. And if that test is met, then there is a registration requirement. However, in the UK, there is a very benign territorial scope analysis, which is slightly different to the analysis that Rudolf was explaining, where you look at where is the investor. In the UK, the territorial scope analysis for crypto asset services providers is basically whether the crypto asset service provider either has, operations, physical operations in the UK. That means that staff and decision making is in the UK, or whether they hold themselves out as being in the UK. So if they say, well, we are a UK company, even if they're not, then that is triggered. And so I think it is relatively easy at the moment to avoid the UK regulatory framework simply by not having a presence here, because approaching customers does not trigger the regime in the UK.
Yeah, I think the anti-money laundering is basically the one point where regulators across the world agree that as a minimum, no matter what else you require or do not require, there should be checks in terms of identifying who the players are in your marketplace and determining beneficial ownership, different requirements depending on what you do. Even if you set up in more, let's say, exotic kind of low regulation places, I think the anti-money laundering is one that everybody more or less tries to comply with, so that if you are targeting investors in bigger jurisdictions like the US or the EU, you're not failing the requirements there as a minimum.
Fantastic. Thank you so much. Diego, we've been talking about NFTs as digital art. Have you seen NFTs being used in other contexts? And perhaps you could tell us about what we should maybe look out for in 2022.
Of course. Just before I answer that, Frankie, I was thinking that one point I wanted to add to what we've been talking about earlier around regulation, which people may not appreciate, is that it is true that getting regulation is a little bit regarded as a badge of honor. I would like to add to that sometimes people try to get regulated and the applicable regulatory framework just does not apply or is just not helpful to the existing business model. And I've seen frustration in that sense as well. So it's a really difficult situation for market entrants at the moment, because those that want to be entirely outside of the radar, are treated as you're not regulated and therefore you're not, worthy to be dealt with from an institutional perspective. And those that do want to be regulated and sort of come to the regulator, they really struggle to apply the existing framework that's there. So, because the rules are not designed for crypto assets, they're not designed for DLT platforms, they're not designed to work, they're designed for securities in the traditional systems that we've got. And so it is a really weird and strange situation to be in. You're either outside or you're inside, but in both cases, you really struggle because the regulatory framework is just at the moment not tailored. I think that will change. There are changes in law, and there are things that are coming down the pipe which are going to make that better. But at the moment, it's just really difficult. So that's on that. And then just on uses of NFTs, I think you really need to treat NFTs as a type of technology almost, because it can be used for so many different things. We've had a client that asked us about, could we use NFTs for ticketing purposes? So if you've got a season ticket for a venue, could that be done in an NFT? And absolutely it could. But all of a sudden it changes its nature, and you no longer, or some of the concerns that we've been talking around investment purposes and whether you're holding it to gain value, etc., go away, because they're the same issues that you would have if you're holding a ticket, a season ticket to something. So you see, I think that illustrates quite clearly that an NFT, can be used, yes, as digital art and a way of selling digital art, but really it's the underlying technology that makes it so fabulous. And it's the ability to transfer it, and it's the ability to make something unique in the digital space. And so I think the uses of NFTs are really limitless. It's just how creative is somebody, and they'll come up with uses. I've mentioned the ticketing thing. I've heard ideas about trying to put prospectuses and little flyers in NFT forms so that you can collect them. Other things that prove ownership, like for example, title deeds for property have been floated around, whether that would be possible to create an NFT form. So we've seen lots of different types of proposals. I think the key is it's coming. NFTs are going to be a way of doing lots of things that currently exist differently. But I think we need to treat NFT as technology and not as a thing in its own.
So, Alana, to start with, I really wanted to talk about the NFT sellers who are, IP owners such as artists, musicians, media rights holders. Could you help start us off and explain where artists should go to mint and sell their NFTs?
Yeah, absolutely. Well, I'd say the most common way at the moment for artists to mint and sell NFTs is via an NFT platform. And it's essentially an application that's built on a blockchain. And these platforms facilitate the minting of NFTs on a specific blockchain. So it's effectively making the whole creation of an NFT more user-friendly. For example, OpenSea, they've got like a minting tool that you can use. And you can use it, to make a collection of NFTs or, any one-off NFTs for free. And you can all do that without, even a single line of code. So I think that's really what I mean when I'm talking about kind of user-friendly experience in minting NFTs. Like, you don't have to know how to code in order to use a lot of these more mainstream NFT platforms.
And I think that stops a lot of artists from doing it because they hear all of this terminology, NFTs, minting, tokens, and that might sort of scare them away. But actually, it is quite a user-friendly experience. So that's good to know. And in your line of work, you've been working with some art projects which are collaborative pieces. Could you tell us a bit about how collaborative works of art can be sort of minted?
Sure. So, in my work with the Serpentine Legal Lab, we just did a big research project on collaboration or legal issues and collaborations across art and tech and art and science. And what we found, in particular when it comes to NFTs and NFT platforms, is that a lot of the more mainstream platforms are not really designed for collaborative projects. They're really modeled on this idea of the singular author who sort of comes up with the idea and really puts that idea into material form themselves. But actually, in today's contemporary arts world, a lot of projects that do have a new technology element to them, whether it be something like augmented reality or artificial intelligence, a lot of those projects are created collaboratively because they rely on people with different skill sets. But look, with these mainstream NFT platforms, if you care to, read the website terms of service, which not exactly your friendly bedtime reading material, but if you were to make your way through one of those documents on a place like OpenSea or Nifty Gateway or even Super Rare or Rareable, any of those, they really expect the person doing the minting to be the author of the NFT, to be the person who has all the rights to the work that they're creating. And so we have this sort of kind of, disjuncture between how works are really created today and how NFT platforms see how artists are creating works today. There are some anomalies, and I have found that over the last few months, some of the platforms have gotten better to accommodating collaborative projects. So look, now on Nifty, for example, you can split royalties amongst more than one user, and Foundation is a really good example as well. So when you're minting a work, you can select more than one user who will receive the sale royalties. So they are slowly evolving. I think it is getting better, and as we see more kind of creative NFT projects, more collaborative NFT projects, I do think that some of these terms are going to have to be updated again to accommodate that.
Great. Well, I know obviously musicians and bands, they have had to work collaboratively, obviously. But then on the art front, you have groups such as Banksy, which is more than one artist. What would your recommendation actually be for collaborative groups of artists? Would you say that they should actually set up their own entity to represent them as a group before going onto a platform, or could they go straight on and work together on, say, Nifty Gateway?
Yeah, I mean, that's a super interesting idea, the idea of like creating an entity. And then you get into these kind of like artist-led organizations which produce works collectively. I mean, I would probably say that in almost all situations, a good starting point is an old-fashioned written contract, which spells out everybody's obligations. So who has to do what, when, and the consequences if they don't do that. And yeah, I think it's probably worth going down that path and then going to, your platform like Nifty Gateway, which does split the royalties, which, is great because it does make it automated. You don't have to think about it, but it's still, it doesn't go to the extent of working out, for example, I don't know, down the track, who has the rights to sell that NFT in certain ways? Could it be fractionalized down the track? Would you have to ask the other co-owners of the NFT for permission before fractionalizing it or selling off your half, or actually becomes really complex when you think of the potential lifespan of an NFT and what these collaborations might look like in the future. So yeah, I think putting pen to paper, or typing it out can be just a really useful way of also, getting all the collaborators to kind of really think about, okay, well, what do we want to happen to this project down this track, and how is this relationship going to work down the track? So yeah, I think that would be my first port of call, a written contract.
That's really fascinating. And I've had conversations with a photographer who has photographs of Jimi Hendrix, The Doors, some really iconic photographs. And he wanted to mint the NFTs and obviously has to go to the estate for the sort of image rights side of things to get permission. And on that sort of the image rights side of things, if you are an IP owner and you've got media rights and you've got sort of film and TV content and a whole catalogue of media, could you, as a media rights holder, mint that as NFT?
Yeah, absolutely. Well, I think, look, NBA Top Shot is a really great model. They've built a whole platform based on their content and to sell their content effectively. I mean, it also kind of springs to mind a couple of recent legal disputes that have arisen in the NFT space. So some people in the audience might have heard of the Quentin Tarantino dispute. There was a recent NFT conference in New York, probably about a month ago now, called NFT NYC. And Quentin Tarantino, was part of a panel discussion. You can actually watch it online still, where he announces that he's like the celebrity artist that's going to mint these secret NFTs, and he's going to be taking certain content from Pulp Fiction, and I don't think it's necessarily scenes. I think it was proposed to be he was going to take photos of the script, like his handwritten script or like a hand typed script. The producers of the company that produced Pulp Fiction has I think they initially issued Quentin with a letter of demand, which I believe was ignored. And then they filed a claim, a lawsuit, basically, arguing that this content is theirs and he doesn't have the rights. He's not the owner of this content. They are the rights. With film, it gets super complex as well because there are so many layers of rights that are involved, and it's not necessarily easy to work out who has the right to do what with it. So again, that's why having that clear-cut contract from the beginning is really important. And it's not that easy to make a clear-cut contract from the beginning because, as you can see, technology evolves over time. So I'm sure when they originally wrote the Pulp Fiction contract, they weren't even contemplating this idea of NFTs. But, contracts can be updated over time as well. You can add in additional clauses as long as the parties agree and, they probably should sign for it. So it is possible for contracts to evolve over time to accommodate these new types of formats in which this content can be used. And there's a whole recognized genre of art history, appropriation art, which uses found content. So in a way, a lot of the IP issues that we're seeing arise now in the NFT space. They're not new issues. We're just seeing them arise in a different context. So I think we can seek some comfort in that we do have some precedents with legal cases in different jurisdictions, which look at, how much found content might be acceptable to use in a certain situation.
That's, fascinating points about Pulp Fiction and this big announcement that he made. That's so funny. So you mentioned that, artists who go on to an NFT marketplace and they're trying to mint their artwork, they don't need to know how to code. But in order to create a licensing agreement, are they responsible for creating that licensing agreement? And if they are, what should effectively be included?
Usually not. Like, again, it comes down to each individual NFT platforms, and your starting point is really looking at their terms of service. So the terms of service, I should say, are effectively a contract between the platform and the user. The way that NFT platforms have approached the licensing aspect. So by licensing, I think we're referring to the permission for a purchaser to use their NFT in certain ways that would involve using the copyright owner's exclusive copyright. So like reproducing the work, or what we call here in Australia, communicating to the public, which is essentially transferring something electronically or uploading something to a website, or maybe sharing an image of it online. Different NFT platforms spell out the licensing arrangements differently and in different ways and in different places. So the standards when it comes to license arrangements are still not quite there yet. I do think we're going to see those, really come together in the next year or so, where there will be more uniformity between the platforms in terms of like what the scope of these licensing arrangements are. But they're just not quite there. Then you also have to think about, well, how does this license arrangement between not necessarily the NFT platform and the user, but the purchaser or the seller and the purchaser work? Because that's like a separate contractual arrangement, your transaction between the seller and the purchaser. At what point does the buyer, when they're looking through the NFTs to buy on this platform, do they sort of come to understand certain rights or restrictions that come with buying the NFT? So look, all platforms have different ways of kind of notifying users of that. Some do it better than others. And so a lot of my work with NFT platforms in the last few months has really been about thinking about, well, what's the best practice approach here? So how can we make the rights of using an NFT clear and transparent, both the seller, whether it be the artist or a secondary seller, and the purchaser as well. Interestingly, there are some platforms out there, Feral File, for example, users, they also actually upload this kind of like template agreement that they expect the sellers and the purchasers to enter into when they're transacting via the platform. I think there's some really interesting legal issues that come around with that, because this kind of question of, can you expect other people to enter into a contract that you're not privy to? So it's this kind of whole area of local privity of contract.
So if an artist has some physical artwork and they've priced it and now they're making it into a digital piece of artwork, how should they go about pricing that piece of art?
Yeah, it's an interesting one. Look, I think actually in reality, a lot of work that is being minted as NFTs doesn't actually sell. I think we hear a lot about the really extravagant prices that are being paid for this or that CryptoPunk or ape or whatever. But if you actually look at the sheer number of NFTs that have been being minted every day, like a lot of them are not being sold. A lot of them will just sit there being listed for months on end. So, when it comes to thinking about what kind of price to put to your NFT, I would definitely recommend artists start off slow. And I also think if the artist has a record of selling physical artworks, then they should consider setting their NFT floor price, which is a kind of a crypto word for like kind of your base level price minimum that you'd accept. Just think about making it consistent with your broader market.
Great. And when the NFT is resold, could they get royalties then as well?
It's possible. Of course, one of the main benefits that are flouted with NFTs is that compared to more traditional art market transactions, resale royalties are automated, so they automatically trickle back to the artist. And I think while we often hear this message that artists don't otherwise receive a royalty, I think we need to keep in mind that that's a very US-centric position, because in the US, there are no royalties guaranteed at law. But resale royalties are a legislative requirement in many jurisdictions, more than 70 countries around the world. They all have legislative requirements for resale royalties for artwork. In Australia, for example, we have an artist resale royalty scheme that came into play about 10 years ago, and it applies to all commercial resales of artworks over Australian $1,000, and that they need to be reported, and then 5% of that royalty is payable on the resales. Most NFT marketplaces do build in this kind of automated resale function into transactions on their platform. Some even offer like a kind of a flexibility where you can choose the level of resale royalty. So like Nifty Gateway does that now, or Rarible as well. And we talked about this idea of splitting royalties as well. So that would apply to the secondary market. But in reality, I think there's a lot of misconceptions about how these resale royalties get triggered. So if you look at the ERC 721 smart contract standard, which is used for most NFTs sold on Ethereum, there's no mention of a resale royalty in that code at all. So it's actually not at the smart contract level. For it to kick in, it gets triggered at the platform level. So not at the smart contract level, but at the platform level. So at the level of Nifty Gateway or OpenSea, that's where the resale royalty gets triggered. And the problem with that is, what happens if you buy an NFT on OpenSea and then you want to sell it on Nifty Gateway? Well, the resale royalty will not be triggered. Or what if I just want to transfer my NFT from my wallet to your wallet, and it's a completely private and direct transaction and there's no middleman involved at all? Well, then again, that resale royalty won't be triggered. So you can almost override it in certain ways. But I do think it's worth digging deeper when you're looking at which platforms you want to use, whether you're minting a works or you're looking to buy works as well, to see how these resale royalties actually work in practice.
Very, very interesting. So in a way, NFT platforms are similar to other creator platforms like, say, YouTube. And when you're on YouTube and you're an artist and you want to do a live stream of your music, it will query to see, does this person actually own that music, or is this, a copyright infringement issue? As far as I know, on NFT platforms, almost anyone can mint anything. And that obviously brings up lots of issues to do with counterfeit NFTs and piracy. And then if we take it one step further, some of these artworks are actually created through code, through algorithms. So as the creator of that, you can almost take yourself out of that equation, because it's actually the code that created the artwork in the first place. So it becomes really confusing. But in the case of counterfeit NFTs, what can you do? Maybe that NFT is just being resold. Who should you go to? Should you go to the NFT platform, or can you go to the creator themselves to get that sort of taken down off the internet?
I think it's good that you mentioned YouTube, because in many ways, the process that you would go through with YouTube, if you found that your content was being used without your permission, is a similar process to how you would probably approach an NFT platform that's listed an unauthorized NFT. A lot of the mainstream NFT platform website terms of service, they'll cover the process by which you can make that sort of a complaint to them, especially those that are registered in the US. They require that you follow the DMCA, essentially the Digital Rights Management Act. And essentially what it requires you to do is to either complete a form, or where you're explaining that you're the copyright owner, and then you have to nominate what the infringing content is, submit it as a kind of an official DMCA. And that can be sent to the NFT platform. It can also be sent to the ISP, the Internet Service Provider, as well. And they are then supposed to delist that content. And by delist, though, I mean they'll probably get rid of the listing, but you've got to remember that if this NFT has already been minted, there's nothing they can do about that. That NFT is permanent, it's immutable, it's always going to be on the blockchain. So in that way, it becomes particularly problematic that, so it might not be visible, but you know that the NFT is still there. And then they give the alleged infringer an opportunity to respond to the DMCA notice. And if that person does respond and they say, you know, oh, well, we actually haven't infringed your content, then you're going to have to pursue another avenue to get it taken down. So usually that'll mean then you're going to have to file a claim for copyright infringement in appropriate court. I mean, it's probably also worth noting that in the last year, particularly in the last 6 months, we have seen a lot of these kind of copycats, NFTs coming about, and also, you know, just artists discovering these NFTs that have been minted based on their content. And what I have noticed is that, you know, some artists, like what they will do when they find this has happened to them is they'll take to Twitter and they'll call out that copycat on Twitter. It's got its pros and cons. The pro is it's very cost effective, especially compared to, you know, hiring a lawyer and pursuing a lawsuit. At the same time, it's highly risky and you have to be very, very careful with what you say. You can shoot yourself in the foot and someone might sue you for defaming them potentially. What seems to be happening, though, is when there is a big call out on Twitter, I have heard of many occasions in which the platforms actually do decide at that point to take the listing down because, you know, they're concerned about their reputation. It's a highly competitive space at the moment with, you know, new NFT platforms popping up every day. And so building that kind of consumer loyalty is really important. So showing that they're kind of acting on this kind of bad conduct is really important for the platforms to do as well. I actually heard recently of this digital art platform. It's called DeviantArt, which has created this free copy detecting AI, and it basically helps artists find misuses of their work online. I'm sure if you just Google DeviantArt and copy detecting AI, you'll find it. But I've heard that's been quite effective too.
Amazing. Well, thank you so much. That's fascinating and good to know that there's a good use for the Twitter mob. And as you said, it's a case of reputation at the end of the day. So there's no point allowing, as an NFT platform, allowing that sort of behavior to take place. And it's in their best interest to implement an AI solution or be really super responsive to any claims. Thank you very much. Andrés, does an NFT purchaser have a copyright in the existing artwork or merely in the digital copy owned?
Well, Francesca, I think that that's a really interesting question. And I think that I would say that is, from the legal perspective, is one of the main issues that we're dealing right now of exactly, first of all, what is an NFT? And to answer that, we need to really take a look at what is exactly happening on the technical side. And if we take a look at the different projects out there, I mean, we've seen so many things and so many variations on different kind of NFTs and how they are, you know, set up. And obviously that has an impact on exactly the rights that are being transferred. I mean, we've seen stuff really complex where the actual copyright, the actual work of art is introduced, is embedded into the NFT itself, which in that case, one could argue that there is an actual copyright in that sense, that the author, the creator of the art is actually putting out in the market, is creating it and selling it to a purchaser. And we have seen other cases where the NFT is merely, if you want to call it a receipt or if you want to be a little bit more benign with the NFT, a proof of ownership of it, and that's it. So what is exactly happening on the legal side when it comes to the intellectual property? I think that it's an open-ended question, and it taps into a bigger discussion about, in general, virtual assets and particularly cryptocurrencies and tokens, about exactly if we can own it or not. I mean, if it falls within the category of being ownership, and we put it into the category of real rights, for example, in the typical civil law jurisdictions. Should we treat it as an obligation? I mean, as a contract. I mean, as a contract, as an obligation between two parties. In this case, for example, the NFT, the author, and then the subsequent purchasers, and etc. Or, I mean, we are dealing with something that is completely new, and we need to develop new categories to deal with that. So, particularly when it comes to your question, I think that in general, I mean, we have to take a look at the different, NFTs and concrete projects. Most of them do not grant a copyright over the art. They are merely, as I said before, a receipt, a proof of something, a proof that you are the owner of that, and that's it. And in some cases, we've seen that there are a little bit some more complex structures when it comes to the legal framework of the NFT. And we are seeing some cases, for example, in the case of the Bored Apes, in that case, there is an actual transfer of the copyright, but the transfer of the copyright, I mean, if we take a look, for example, at the NFT, the license, the contract that transfers the copyright is not in the NFT itself, but rather is located in the platform that the Bored Apes were distributed. So again, we are seeing that the legal structure for the NFTs is absolutely varied, it's completely diverse, and we really have to go on a case-by-case situation and analyze what is happening in that case. Perhaps, and taking a little bit more of a deeper look into the NFTs and actually the configuration of using the smart contracts and using blockchains for all of this is opening up a discussion that in academia is really interesting, the kind of discussion that this has opened, in the sense of, can we actually consider, for example, the code on a blockchain as a written agreement? Can we consider it as a contract from the legal point of view? Can we consider code as another language? I mean, we can write a contract in English, Spanish, Italian, Chinese, whatever. Can we actually consider, for example, Solidity as a valid language to write a contract, and using that contract written, drafted on a blockchain? Something that we've seen a lot with smart contracts, and a lot of projects that are actually going in that direction. For example, open law, etc. I mean, they're moving into the direction of actually considering the code as a written contract. That's one thing. And the other thing is actually, okay, let's assume that we can actually consider that code as that piece of code as a contract. Did we sign it? I mean, in most cases, for example, for transfer of copyright, for a licensing agreement, whatever, you usually need to sign it to be considered as a contract. So the electronic signatures that are being used in the different blockchains, and obviously we are entering into that whole sort of discussion about the different types of blockchains, how they operate, and all of that. But I mean, in general, we can pose the question of actually, are these signatures, these electronic signatures, considered as an electronic signature in the legal sense? I mean, for example, if we take a look at Europe, and probably it's a model that is copied all over the world with the AIDAS regulation. I mean, you have different categories, and no matter what category you fall into, I mean, that electronic signature is considered as a valid signature. We can then argue exactly what are the legal effects that kind of electronic signature pose, but it has, I mean, it shouldn't be disregarded merely by the fact that it's an electronic signature. So it also taps into that other discussion. And I think that when it comes to NFTs, as I said before, I mean, it's really varied, the kind of situations. And in most cases, I mean, from what I've seen in platforms and NFTs themselves, in most cases, there is no transfer of the copyright of the underlying work. So you have an issue there. But again, I mean, this is a sort of a playing field, I like to call it. And we are just experimenting in that sense. So obviously, as we move forwards with all of that, I mean, we're going to start seeing, the actual art, the actual work, the actual thing that is protected under copyright embedded into the NFT. And probably then it will make sense to start discussing about this. Hey, actually the code of the NFT, is it actually containing, all the details, all the agreement? Is it actually governing the copyright itself, how it can be assigned, in which territories can be used? I mean, because we're dealing with, NFTs is dealing on the online world, and we jump into this discussion or this idea of, there are no borders, etc. But again, when you need to, enforce legal rights, you have to rely on borders. You have to rely on jurisdictions. So that's also another issue, that transfer of a copyright or the licensing agreement. I mean, exactly in which jurisdiction does it have a place? Does it have a time limit? So a lot of questions that are usually unanswered, and that's why, taking that restrictive approach that you can see in general when it comes to intellectual property, clearly in that sense, we are not seeing transfers of copyright when it comes to the NFTs, but rather, just the NFT as itself, as that receipt that some people are giving it value, and that's it. So there is a lot of, buyer beware in that sense when it comes to buying NFTs in general.
Thank you. You raised some really fascinating points. And I think that we might see the emergence of a new industry, which are sort of legal technologists who understand the law and also understand how to code when it comes to smart contracts, algorithms, and so on and so forth. So you mentioned that in the case of the Bored Ape Yacht Club, that there was actually a transfer of intellectual property. Does that mean that as the owner of that NFT and the intellectual property, that I could create merchandise and sell that? And I'd love, Rudolf, as well, if you have some opinions on this. If in terms of the secondary market, if I was to sell that NFT and to buy it back, what are the implications there?
Well, I think, Francesca, that the question is also really good in that sense of, asking what are the exact limits when it comes to that. I don't remember exactly the licensing agreements, the specific terms in the case of the Bored Apes, but I think that it was pretty generous in that sense. It was pretty lenient. So pretty much the purchaser of the NFT could basically do whatever he or she wanted with the NFT. Not only reselling it, but also developing merchandising or creating as it's called in intellectual property derivative works from the art, from the original work. So if the licensing agreement was pretty lenient, pretty generous in that sense, obviously the purchaser and subsequent purchasers could obviously create derivative works from the original artwork. Again, as I was mentioning before, as in most cases, we don't have a transfer of copyright. A transfer of copyright or a licensing agreement. Again, the situation is a little bit more complicated for a purchaser to actually be creating derivative works from that original piece of work. So, assuming that we have a situation where that person can actually create that secondary work, again, it will be possible. Obviously bound by the terms of the original licensing agreement. That again should be, this is, I'm bringing up a little bit more of my background as not as part of academia, but rather as a practitioner, in the sense of if you're granting a licensing agreement or a transfer of copyright, detail it as much as possible. Detail what can be done, what cannot be done, and also not so much because when it comes to the economic rights associated with the work, but also something that has to be contemplated, especially in jurisdictions that are recognized. I mean, the moral rights over the piece of art, the work itself that is protected under copyright. I mean, even if the original creator, assigned the copyright, transfer the artwork, the protected art itself, is he or she still has, clearly some moral rights over the artwork, and that derivative work cannot infringe or go against that first original idea that the author had. So also that should be taken into consideration in dealing with that. And obviously, when it comes to secondary markets, I mean, and I think that Rudolf probably can answer it much better than me, in the sense he's being the expert in capital markets and that. I mean, we have a clear situation, because if there was no possibility of doing that derivative works, clearly there is a breach of contract by the purchaser in that sense. So when it comes to the original contract with the creator of the artwork. So again, you have suddenly a derivative work that is absolutely in breach of the original contract and in breach of the existing regulation.
So Andrés, should artists be concerned about personal information when it comes to minting an NFT?
Well, Francesca, I think that when it comes to that topic, I think that it's a concern that has been raised quite a lot of times in the last couple of years. When it comes, not only, I mean, when it comes to NFTs, obviously we are, speaking about, the last couple of years, but actually when it comes to blockchain and decentralized technologies in general, I think that it's a question that has been raised quite a lot of times. There has been, several amounts of papers written. A couple of regulators have raised their points, like, for example, the French Data Protection Authority in Europe. And I think that it's a tricky question. And I think that I'm going to, relying on my background as a practicing attorney and saying it depends, the answer, in the sense of we have to be, really specific about what is exactly happening in that situation. obviously we need to discuss, are we discussing about the introduction of personal data on a platform level, for example, at the level of the Ethereum blockchain, for example, let's say that it is the most used when it comes to NFTs? Are we talking about a particular dApp that is being used to mint NFTs? Are we talking about introducing personal data in the process or the business flow of a particular business or a particular platform that is being used for this purpose? So depending on the level, obviously the answer will depend. And also something that needs to be factored in is the type of blockchain that we are using, for example. That's something that usually we tend to put everything in the same bag, public blockchains or private distributed ledgers. They're not exactly the same thing. There is a lot of there is a clear lack of consensus in general between regulators and academia and practitioners when it comes to this question of actually what is decentralized, what is exactly when it comes to a public blockchain, and actually when it's actually from a factual point of view impossible to assign roles, because when it comes to personal data, basically we are assigning all the obligations, as pretty much in most of regulated fields, to a single entity, the data controller, and we are putting that person in charge of making sure that there is a legal basis to process personal data, that transparency obligations were complied with, that security measures were adopted, that in some cases, for example, a data protection impact assessment was conducted, et cetera, et cetera, et cetera. So we're putting all those obligations on that person, pretty much as in any other field. For example, in the case of securities, we're putting it into the issuer of the security, for example, when it comes to anti-money laundering, to the obliged subject. Usually law puts obligations on the head of somebody. So when you take that question on a real decentralized situation, for example, on the blockchain of Bitcoin, who is the data controller in that sense? Even with Ethereum, who is a data controller? Every single node that is operating on the network, every single miner. Obviously now with Ethereum, with the change in the protocol and all of that, obviously the answer might change in that sense. So I think that it's not an easy answer. In general, I believe that as we're seeing now how things are operating, I think that in most cases, most personal data is being stored at the service provider level, in this case of companies that are facilitating the process of minting an NFT, because the amount of metadata that the NFT can actually hold, just from an economical point of view, it's expensive, to be expending Ether to actually, put that all information in the Ethereum blockchain. So it doesn't make sense to, be uploading information. But even if it was possible, from a practical point of view, it should be minimized as much as possible, as it's actually happening. I think that I haven't seen any case of, personal data being introduced into the NFT. I think that in most cases, the relevant personal data for NFTs, and especially when it comes to the transfer and all of that, usually happens off-chain, usually happens at the service provider level. For example, in the case of the typical licensing agreement, in most cases, the very few cases of licensing agreements that we have seen or transfers of copyright, identifying the parties, who is the author of the artwork, who is the purchaser, the terms, etc., are being, drafted in a contract, in a traditional contract, if you want to call it, in comparison to a smart contract, and it's happening off-chain. And in that sense, no personal data is being introduced into that situation. So again, it's a situation that varies. And right now, what I'm seeing in the state of the art, in general, I would say that authors shouldn't be concerned about this. But again, it's something that it's a valid point to raise, but it's a situation that we have to be very careful when it comes to addressing that question, because the consequences can be, really troublesome. Like, for example, as I was mentioning before, trying to find who is the data controller, who has to comply with all of this, regulatory regime in a public blockchain can be a tricky question, not only from the practical side, but also when it comes to enforcement. Try to, put all the nodes of the Bitcoin blockchain in line, complying with this kind of regulation. It's tricky to say the least.
Thank you so much for your insights. And as you pointed out, that this isn't the end of the story. We'll have to keep an eye on how regulations change, different use cases that come up. But I think that's a sort of optimistic end to today's talk. I'd like to thank you all for joining me today. Thank you so much Rudolf, Diego, Alana, and Andrés. It's been an absolute honor speaking with you, and I hope that we can stay in touch.